I rise to move the amendment in my name and the name of my honourable friends to defend the rights of female prisoners. This is not something I ever imagined I would have to do. In my 38 years in Parliament, I've always supported the rights of women, but I was never a champion because there were a large number of parliamentarians far better qualified than me, and because I thought that women's rights were generally headed in the right direction. Not as quickly as they should be, but in the right direction nevertheless. Now I find that the rights of women are under the greatest threat I have seen in my whole lifetime. Not just their rights to safe places in bathrooms and changing rooms, NHS single-sex wards, and in prison, but their whole existence as biological women is under existential threat, as some people, nearly all men, seek to erase the word women from the lexicon or commandeer it for the use of men who identify as women. Now let me be crystal clear, my lords. I completely support the right of men, as guaranteed in the Equality Act, to change their gender and to identify as women. They must not be discriminated against. But let us be equally clear that men who identify as the female gender are not biological women. Because, my lords, it has been said before, only women have a cervix, only women have a womb and bear children, and it is not transphobic to point out that elementary biological fact which has been at the root of human existence for countless millennia. I believe the threat against women is increasing daily. Young lesbian women are being condemned as transphobic if they refuse to have sex with men who claim to be women. What a perversion of common sense and reality that is. But it's worse than that. The police say there's been a doubling of crime by female paedophiles. No, my lords, that is a big fat exaggeration. Sexual abuse by women has increased, but it is still infinitesimally small in comparison to men. Lynn Owens of the National Crime Agency says that the problem of male paedophilia may be 7 times higher than at first thought. There has been a huge increase by male paedophiles, some of whom then describe themselves as women, and of course our thoroughly woke police force swallow that nonsense and record it as if the rape and sodomy of children was being done by real women. Our police force, some of them, are trashing the reputation of women by accusing them of crimes being committed by men. So I believe that the message should go out to the police service that when a male is arrested or commits a crime, he should be recorded as male and never as female, no matter how he designates himself. And then, my lords, we come to prisons and the substance of my amendment. And I'm afraid the situation there is just as bad. Now, I'm in a minority, I suspect, in this House, on many things I am. I'm not one of those who believes that women should not be sent to prison. When the crime justifies it, then women should go to prison and be punished. But, my lords, that punishment should not include the threat of rape and violence from big brute rapers who have decided to identify as women and get sent to a women's unit. The female prison estate is currently run as a mixed-sex institution. This is because the MOJ policies permit prisoners of the male sex, where they identify as transgender and where they fulfil certain criteria, to be allocated to the female estate and held in women's prisons alongside vulnerable female offenders. Eligible males include those convicted of the most serious, violent and sexual offences and those with intact male genitalia. Amongst others in prison at the moment, there is a vile man, and I actually describe him as a vile man, who raped 2 children, got his gender recognition certificate whilst in prison, and is now swaggering around the female prison wing. I cannot name him nor his prison. I believe that women's prisons should be separate sex and single-sex facilities for reasons of the safety, the dignity and privacy of women in prison. Now, since the Corsten report in 2007, it's been acknowledged throughout the criminal justice system that women in prison exhibit patterns of vulnerability that distinguish them both from women in the wider community and from male offenders. Female offenders report disproportionately high rates of previous experience of violent and sexual abuse and experience high rates of mental health problems. Indeed, in the last debate, I heard the noble Lord Dubbs say that 3/4 of women in prison had suffered from male violence themselves before being sent to prison. And in fact, a recent study in Scotland, of prisons in Scotland, found a high prevalence of significant head injury of almost 80%. These injuries were most often caused by repeated incidents of domestic abuse occurring over several years. Now, for many female prisoners, time in prison is often the first opportunity to tackle the complex issues around their offending, improve their health, and access the services they need. Where women in prison have been the victims of sexual and violent assault, prison is often the first time they can be confident that they'll be away from their male abusers. And where women in prison have been the victims of sexual and violent abuse at the hands of men, the presence of any offender of the male sex may have an inherently traumatizing effect, regardless of the nature of offence committed. It is for good reason that approaches to tackling female offending have consistently emphasised the need for trauma-responsive services. Now, the Ministry of Justice policy that permits prisoners of the male sex to be housed in the female estate is called the Care and Management of Individuals who are Transgender. The policy states that all male prisoners who identify as transgender and who are in possession of a gender recognition certificate must be allocated to the female estate. The conviction, offending history, risk profile, anatomy are of no consideration. Theoretically, a decision may be made to transfer to the male estate after risk assessment. We know of no situation where this has happened, my lords. Even the most high-risk male prisoners have remained in the female estate, including those convicted of violent and sexual offences against women and those with intact male genitalia. My lords, in respect of male prisoners who identify as transgender and who have no gender recognition certificate, initial allocation is to the male estate. The prisoner may then make an application to be transferred to a women's prison. Now, in March 2021, a judicial review was brought against the Secretary of State for Justice, challenging the lawfulness of the MOJ's policies that permit prisoners of the male sex to be housed in the female estate. Judgment was handed down in July and found that these policies are not unlawful. Well, I do think, my lords, it would be quite extraordinary if the MOJ was found to be operating an illegal policy. However, the judgment was clear that the court had been called upon to rule as to the lawfulness of the policy, not its desirability. Lord Justice Holroyd acknowledged the negative impact of these policies on women in prison. He said, quote, "I readily accept that a substantial proportion of women prisoners have been the victims of sexual assaults and or domestic violence. I also readily accept the proposition that some, and perhaps many, women prisoners may suffer fear and acute anxiety if required to share prison accommodation and facilities with a transgender woman who has male genitalia, and that their fear and anxiety may be increased if that transgender woman has been convicted of sexual or violent offences against women." He also went on to say, "I fully understand the concerns advanced on behalf of the claimant. Many people may think it incongruous and inappropriate that a prisoner of masculine physique and with male genitalia should be accommodated in a female prison in any circumstances," unquote, said Lord Justice Holroyd. Well, I agree with the noble and learned Lord. I agree that it is both incongruous and thoroughly inappropriate. It is lawful to house prisoners of the male sex who have been convicted. If it is lawful to house prisoners of the male sex who have been convicted of the most serious violent and sexual offences alongside women who have been the victims of violent and sexual assault, if that is the law, then, my lords, that law must change because it is wrong. Now, under the Gender Recognition Act of 2004, people who fulfil certain criteria are able to obtain legal recognition of their acquired gender. Legal recognition will follow from the issue of a gender recognition certificate by a gender recognition panel, and a new birth certificate is also issued with the sex marker changed to reflect the acquired gender and the name changed to the newly adopted name. There is no requirement for surgery or medical treatment in order to obtain a GRC. GRCs have been obtained in prison by males convicted of violent and sexual offences who have then transferred to the female prison estate. Now, I do not consider that the original intention of the Gender Recognition Act was to enable violent or sexual offenders of the male sex to be housed with women in prison, much less those who have retained fully functioning male genitalia. I would also make this point. These male prisoners want to identify as women. That's perfectly okay. But apparently, they do not want their male bodies, but every single one of them have retained their male genitalia as they swagger around female prison units. I suggest that those men, particularly those in prison, my lords, are simply faking being a woman to get access to real biological women in the female estate. Clauses in the Gender Recognition Act clearly indicate that a general GRC entitles a bearer to be treated as a member of the sex with which they identify for most purposes, but not all. Hence, possession of a GRC expressly does not affect recording of parenthood. The possibility of being convicted of a crime defined as one that only a man can commit is unaffected by possession of a GRC, as is the possibility of being a victim of a crime defined as one which only a female can be the victim. Primogeniture is also unaffected. I submit, my lords, that incarceration for violent and sexual offences is a situation where a GRC should not take precedence over unchanged biological sex. The MOJ may be acting lawfully, but it is not acting decently, nor doing its duty to protect biological sex women. Indeed, the Ministry of Justice policy documents do not talk about women. They call them non-transgender women, automatically giving top billing to men identifying as women and real women described as non-transgender women. That is why I say that women are being erased from the lexicon. A male, no matter how he identifies, should never be housed in a woman's prison. Like many government departments and organisations, I believe they've fallen for the minority, militant, transsexual agendist, giving far more rights to men who claim to be women than to women themselves. My amendment is a small, first little step to defend women, and I say to my noble friends that there will be many more amendments to come as people realise that the assault on women is now a clear and present danger. My Lords, I commend my amendment to the House.
Amendment proposed after clause 124. Insert the new words as printed on the marshalled list. My Lords, Baroness Brinton is participating remotely, and I call Baroness Brinton.
My Lords, the problem that I think Amendment 214 is trying to resolve is actually already addressed in the very, very strict codes of practice and guidance to the prison sector. And I hope that, given that there is a full system of assessment of transgender prisoners and the prison environment in which they're currently placed, and also a prison environment in which they would like to be placed, it's worth running through the detail of that. Firstly, Lord Blencathra quoted from last year's judicial review, but he'd also said that right when the para 75, where the explanation for the ruling starts, that it's clear that the number of transgender women in women's prisons is small, and the number who hold GRCs and are therefore entitled to be treated as women in accordance with the Gender Recognition Act 2004 is very small, end quote. And I say that in the light of the tone of Lord Blencathra's speech, which made it appear that there was a large invasion of women's prisons of trans women. So the number of transgender prisoners is very small. And the guidance on the management of prisoners, however, is lengthy and clear, because not only do transgender prisoners have human rights, as all prisoners do, but because trans prisoners themselves are at serious risk in prison. The most recent statistics from last year, and in its coverage of the data, the BBC noted the total number of transgender victims far exceeds the number who were suspected of carrying out sex attacks, with only one such case in 2019. In fact, between 2016 and 2019, of 97 sexual attacks in the women's prison estate, 7 trans women had been involved in sex assaults either as the alleged perpetrator or assistant, with 90 of the sexual assaults being carried out by cis women. And a further set of figures from the Ministry of Justice states that 11 trans women had been sexually assaulted in the men's prison estate in 2019 alone. All this tells us that trans women are far more likely to be victims of assault in prisons than perpetrators, and that many more women are assaulted by cis women in prison than by trans women. But even if the number of trans prisoners assaulting others is very low, it is right that there are safeguards in place. So what does the guidance say? It says that after a prisoner declares and can provide evidence that they are living in the gender the offender identifies with, there will be an initial local transgender case board and will, as appropriate, make arrangements for transfers to other parts of the prison estate. The Parole Board published guidance on prisoners who are transgender in March of this year, which sets out the law very clearly for the prison and probation services regarding prisoners who are transgender. The operational guidance says all transgender individuals, irrespective of whether they are located in the estate which matches the gender with which they identify, must be allowed to express the gender with which they identify. However, decisions to locate individuals who are transgender in prisons that do not match their legal gender can be made only on the recommendation of a complex case board. The board will take into account risk factors to the individual and risk to others. So to make it clear, any trans prisoners who might also be deemed a risk to other prisoners, then there has to be a complex case board called for transgender offenders, which will look at the complexity and specifically assess the risk of harm prior to making decisions about prison location. The views of the offender must be presented to the board, but there are a number of healthcare and psychology leads there to ensure that any move to a woman's prison would be safe. Options that a complex case board can consider include moving a prisoner to a woman's prison but keeping them in segregation, or if that's felt even to be too risky, they will be moved into a segregated part of a men's prison, but staffed as if they're in a women's unit. And there are now a small number of transgender prison units. It seems to me that this document sets out well all the steps that need to be taken to protect both the trans prisoner, who, as I've already said, is much higher risk of assault than non-trans prisoners, but also protecting the other prisoners from someone who might be deemed to be a risk. There was the case of Karen White, who sexually assaulted 2 women whilst on remand at New Hall Prison in Wakefield in 2017. It's worth remembering that the prison service had to apologise in this case because they had not followed the procedures that are outlined above, failing all prisoners at New Hall. White should never have been put in a women's prison, and had there been a complex case board, they would have assessed her as being a risk and not put her in a women's prison. The current Ministry of Justice and HMPPS 39-page policy on the care and management of individuals who are transgender says at paragraph 1.6, the proper assessment of risk is paramount in the management of all individuals in our care. The management of individuals who are transgender, particularly in custodial and residential settings, must seek to protect both the welfare and rights of the individual and the welfare and rights of others around them, including staff. Decisions must be informed by all available evidence and intelligence in order to achieve an outcome that balances risks and promotes the safety of all in our care and management. The process is there to protect all prisoners and to respect the rights and safety of all prisoners. My Lords, this amendment is redundant. The actual facts of what's happening with trans women in prisons does not match the opening speech by Lord Blencathra.
My Lords, I rise to support this amendment brought by Lord Blencathra here this evening. And I do so not just because I have attached my name to it, but because I emphatically agree with what is seeking to be achieved. Anyone who knows me is aware that I am an advocate for a strong law and order approach to crime. And those who break the law, the punishment must fit the crime, which often includes imprisonment. What this amendment is trying to do, however, is to protect the dignity of female prisoners. The female prison estate is currently run as a mixed-sex institution. This is because the Ministry of Justice policies permit prisoners of the male sex where they identify as transgender and where they fulfil a certain criteria, resulting in them being held alongside vulnerable female prisoners. Some of these prisoners have been convicted of the most serious violent and sexual offences and are biologically male. My Lords, it surely follows that women's prisons should be separate sex facilities to preserve, as far as reasonably possible, the safety, dignity and privacy of women in prison. My Lords, since the Corson report in 2007, it has been acknowledged throughout the criminal justice system that women in prison exhibit patterns of vulnerability that distinguish them both from women in the wider community and from male offenders. It is also worth noting that female offenders report disproportionately high rates of previous experience of violent and sexual abuse and experience high rates of mental health problems. My Lords, where women in prison have been victims of violent and sexual assault, prison is often the very first time that they can be confident that they will be away from their abusers, which are usually men. I would strongly contend that where women that were in prison have been the victims of sexual and violent abuse at the hands of males, the presence of any offender of the male sex may have an inherently traumatising effect, regardless of the nature of the offence committed. It is the Minister of Justice policy, namely the care and management of individuals who are transgender, that permits prisoners of the male sex to be housed in the female estate. The policy states that all male prisoners who identify as transgender and who are in possession of a gender recognition certificate must be allocated to the female estate. This is irrespective of any conviction, offending history, risk profile or anatomy, including those who are high-risk prisoners and those convicted of violent and sexual offences against women. I too was going to refer to the judicial review which was brought in March 2021, but the proposer of the motion has adequately covered that, so I'll refrain. Just to again emphasise one line, while the policies are found to not be unlawful, however, I think it should be said again, the Lord Justice acknowledged the negative impact of these policies on women in prison. Furthermore, there is no requirement under the Gender Recognition Act 2004, if people fulfil certain criteria, for them to have surgery or medical treatment to obtain a GRC. It is a fact, and this has already been referred to, that the GRCs have been obtained in prison by males convicted of violent and sexual offences who have been transferred to the female prison estate. The latest data available on the number of male sex prisoners who identify as transgender dates back to 2019. But back then, it was 11 in number. New data, I understand, is available to be released, or expected at least this month. Forcing women to share accommodation with prisoners of the male sex, particularly where those prisoners had been convicted of violent or sexual offences, arguably engages Article 3, the right not to be subjected to inhuman or degrading treatment or punishment. I urge your Lordship's House to support this reasoned and sensible amendment, which is clearly intended to respect female prisoners, including their rights and dignity. Not to do so could be interpreted as not caring how female prisoners end up. Indeed, the conditions they are subjected to could be construed as part of their prison sentence, which of course is not, neither should it ever be.
My Lords, I rise to speak to Amendment 214. Amendment 214 seeks to eliminate the risks and dangers to women in prison by the muddled use in legislation of the terms sex and gender. They are not interchangeable. They have come to mean very different things. Matters have reached such a pitch that I'm tempted to paraphrase the 18th century man of letters, Dr. Samuel Johnson, and say that allowing a person with a full set of male genitals the legal right to serve a sentence in a women's prison is not done well, but you are surprised to find it done at all. It is not, to put it too fine a point, it is barking mad. The defiance of science, biology, common sense and reality can be traced back to the 2004 Gender Recognition Act. This allows men who identify themselves as women to be recognized as women, even though they may be biologically unaltered from the day they came into this world in their birthday suits. The dangers and risks are obvious. Without our amendment, this legislation makes them even greater. The law also allows for new birth certificates to be issued. This without requirement of surgery or medical treatment. For all legal purposes, men become females with just the tap of a key on a computer. Piling absurdity onto absurdity, it becomes a criminal offence to reveal that they were ever born as men. As night followed day, just as paedophiles are attracted to the teaching profession and children's charity, so men with violent sexual intent will be able to seek a gender recognition certificate as a license to molest and rape women. The Ministry of Justice, in its folly, cannot provide figures for men guilty of such acts because, in a policy of self-inflicting catch-22, they are categorized as women. It is surely a fundamental right that women in prison, like women in a gym room or in a women's lavatory, should be allowed to find themselves cohabiting with a person who doesn't have a penis. We all know that women in prison are especially vulnerable. It is therefore unthinkable that we should allow a law for them to be menaced by men incarcerated for violent and sexual abuses. Baroness Brinton says that it's only a small number. But a small number is a number. Is that what the law is about? The law should protect all. The dangers... Sorry, I lost my page. Let me make one thing very clear. I'm second to none in my support for gay, lesbians and trans rights. This has nothing to do with it. I still have the scars from having to fight myself as a young woman for equal opportunities in the male-dominated financial services industry. I still bear the scars of having to fight off crude sexual advances that today would carry a jail sentence. In one case, because I refused to submit to my boss's advances, my promotion was held back for over 1 year. This is why I was once a Stonewall supporter. It fought the good fight and won. The Marriage Sex Act of 2013 was a triumph for the humane society we strive to be. But today I weep from what Stonewall has become. It is now a cockpit for factions fighting over meaning of trans rights, where many assert that biological sex does not exist. It is a modern version of the medieval controversy over how many angels could dance on a pinhead. I find it astonishing how many government departments and corporations have bought into this obscurantism. So things have to change, and change soon. Approval of our amendment would be a start. No person with male genitals should be allowed to be remanded into women's prison or serve their sentences there. If the police insist on entering self-identified genders into their records, they must balance it with biological sex. Will my noble friend the Minister ensure that Amendment 292G, which calls for the police to record birth, sex rather than gender be implemented. Too many things are going backwards. Life expectancy is down, obesity is up, weather is becoming more violent, the world has still not shaken off the coronavirus. Let us not add to our woes by bringing down the curtain on the age of reason by replacing it with the age of bigoted fabulists. Will my noble friend the Minister assure this House that he will not let ideology trump facts and ensure that women are better protected?
Speech ranged very broadly indeed. We are in fact debating a complex penal issue where we have a policy which addresses the matter very sensibly, as the noble lady Baroness Brinton explained. Can I just add one point to this debate? It is not difficult, my lords, to see the danger to people who have been registered as male at birth, but who are now registered under the Act as female, if they were required to be placed in a male prison, as this amendment would require, irrespective of the particular circumstances of their case, so long as they are a sexual or violent offender. It shouldn't need to be emphasised, but I will emphasise it because it is the fact that many of these people have had hormone treatment. Some of them have had reconstructive surgery, which has given them primary and sometimes secondary sexual characteristics of a physical nature. What do the proposers of this amendment think is going to happen to such people if the Home Office is obliged to place them in a male prison? Of course, we would all agree that if there is an offender in custody for a suspected violent or sexual offence and who is in possession of a gender recognition certificate, and that person poses a risk to others in custody, then of course specific steps should be taken to isolate them and to deal with them. But that does not justify or require ignoring a gender recognition certificate in the way that this amendment proposes.
My Lords, it has to be said that when I talk to members of the general public and tell them that it's MOJ policy to allow prisoners of a male sex to be housed according to their self-declared gender identity in a women's prisons, irrespective of whether they've taken any legal or medical steps to acquire their gender, that they don't need to have gone through any physical transformation and still retain male genitalia, which we've heard lots and lots and lots about already in this debate, that they don't need to have obtained a gender recognition certificate even. They just need to declare that they are women and demand that they're moved to the women's estate and it's seriously considered. When members of the general public hear this, they are aghast. It falls under the category of, has the world gone mad? That common sense response may not feel appropriate when discussing legislation, but I think in this instance it may help us to look at this issue in practical real-life terms, not just in abstractions, and that's why I welcome very strongly this amendment. While the amendment doesn't resolve all of my concerns, I welcome in a way the modest, narrow aim it has of removing the most egregious aspect of this situation, i.e. allowing male prisoners who identify as trans but have convictions of violence or sexual offences against women to live with women prisoners. There really is no point in this government issuing strategies and grand words about violence against girls and women if the same government has no qualms about letting rapists share the same confined living quarters as vulnerable women in prison who, let's be frank, can't leave, can't escape because they're locked up by the state. So this amendment's focus is on convicted sex offenders, and it's urgent that the government takes notice. An important note here. When gender-critical commentators and academics raise qualms about the general policy of housing transgender prisoners in the women's estate, they are often dubbed transphobic and accused of holding a prejudiced view of all trans women as sexual predators. But this is a malign caricature, and can I at this point give a shout-out of solidarity to Professor Joe Phoenix, an esteemed and conscientious criminologist who's been harassed and traduced for raising such legitimate concerns. But wherever one stands on this issue, on the general issue, this amendment is specific and cannot be accused of implying that all natal men, however they identify, are per se a sexual threat to women, because that wouldn't be true. We are only talking here about convicted sex offenders, those guilty of violence. However, I still hope this probing amendment might encourage the government to look more closely at a range of issues in this area. I particularly want the government to consider whether the Ministry of Justice's involvement with the controversial lobbying group Stonewall, already been referred to by the Noble Baroness Mayer, whether that involvement in Stonewall with the MOJ over a period of time, as with so many public bodies, may, just may, have led to the skewing of policies in a particular direction. For example, I know how keen this government is on data and statistics. But as Kate Coleman, the founder of Keep Prisons Single Sex, has noted, and this just seems incredible to me, the MOJ admits that it doesn't know how many prisoners identify as trans, because with a gender recognition certificate, they are counted by their new legal gender. So I'm not sure how Baroness Brinton can be so sure of the statistics that she quotes, because the tools designed to assess any threat posed by male prisoners who identify as trans women can't be picked up accurately. If someone with a GRC attacks a female prisoner, it will be recorded as an assault by a woman on another woman. I also want to query who is listened to in this discussion and what is obviously a clash of rights. In the course of that recent High Court ruling that we've heard about, Lord Justice Holroyd outlined the need to balance, quote, the subjective concern of women prisoners with the rights of transgender women in the prison system, which made it sound as though the women, the biological women, were all being overly subjective and the transgender women had rights. But describing one side as subjective and the other with rights misses a crucial point, because actually that transgender woman has an identity that is not an objective fact, but a subjective desire and then a declaration. Why are women prisoners, their subjective but rational concerns, afforded less weight here? Also, when the High Court acknowledged that women prisoners may well be worried and scared about sharing prison accommodation with male-bodied prisoners, the court said that that fear was not enough to outweigh, quote, the desire of some male prisoners to be housed with women. But I wonder, when did the prison estate, or indeed the law, allow its policies to be dictated by prisoners' desires? Having worked with prisoners over a number of years, particularly with debating matters beyond bars, many of the prisoners I've worked with have demanded that they desire decent prison education, they desire retraining, they desire better conditions. And I can tell you now, the prison authorities certainly didn't accommodate to their desires. So why then these desires are accommodated to when it comes to the trans issue? Finally, I'm keen that the government look carefully and use this probing motion to do so at how staff in prisons understand the issue of sex and gender in the context of training being used. In the MOJ policy entitled The Care and Management of Individuals Who are Transgender, it advises staff to complete an e-learning module on transgender identity, and one of the training courses is named Intersecting Identities. Having looked at these, it all rather terrifies me. It's one-sided, jargon-ridden, ideological. I'm hoping that this amendment might point to the government to raise this issue and review the whole issue. But for now, at least, a very modest amendment should be taken seriously if you really mean that you care about protecting women from violent men.
My Lords, I just want to intervene very briefly. I support this amendment because to me it is morally wrong for a physical man to be in a woman's prison. As simple as that. If he has identified himself as a woman and deserves to be in prison, there should be special facilities for people of that sort, which does not bring them into close proximity with women or, if they are in danger, with men. The fact of the matter is, we are denigrating womanhood. We had debates in this House some time ago about the bill to grant maternity leave to the Attorney General, a perfectly laudable and reasonable thing to ask us to do. But in that bill, there was no mention of the word mother or the word woman, the person giving birth. Well, thanks to the pressure from both sides of this House, there was a small advance there, and the government, rather than risk a defeat, altered the bill, the wording of the bill. And that seemed to me to be an entirely reasonable outcome. And what I hope is we can tackle this issue in a calm and moderate way, which has as its prime purpose the defence of women and womanhood. And I think probably the most important person in most of our lives has been our mother. We are denigrating motherhood if we allow physically equipped physical males to cohabit women's prisons. And the noble lady, Baroness Fox of Buckley, referred to a very remarkable young woman in her speech, Kate Coleman. She is a highly intelligent graduate who has had personal contact with a number of the women, the real women, who have suffered indignity and embarrassment and much worse by having physical males saying that they're female in women's prisons. Everyone, regardless of his or her identity, deserves dignity, regardless. If special provisions have to be made for a group of trans people, so be it. But everyone deserves his or her dignity, and particularly deserves it at the most vulnerable moments of their life. A woman in prison deserves it. A woman in hospital deserves it. And my lords, we would be giving way to the slogan mongers and the sort of people who have terrorized that academic at Sussex University if we did not recognize that this is a real issue which deserves to be approached in a balanced, moderate, sensible way which recognizes the physical difference between the sexes. This is a probing amendment. It is not perfect. Very few amendments are. But I do hope that my noble friend, when he comes to reply, will indicate that the government is prepared to talk to some of us who have these real acute concerns and see if some amendment can be fashioned for the report stage of the bill, because this is a real problem which we must not ignore.
So I wonder if I could just follow that up by saying that I think the Noble Lord Cormac's late intervention was helpful in suggesting to the Minister on what I think all would acknowledge is both a complex, sensitive and controversial issue, would benefit from a sensible round-table discussion in which the prison service actually was open to some scrutiny, because I think part of the issue that there is around this whole issue of gender, sex and ID in government as a whole is that policy has been developed mainly by officials who have come under the influence of certain groups, which ministers have basically accepted, and it hasn't been subject to proper scrutiny. And my major appeal tonight to the Minister is to allow for that and to open up a dialogue in which those of us who are gender critical are not accused of being transphobic, which of course, or being under the pay of outright American organisations, which of course I'm afraid has all too often clouded the debate. I have an oral question about Professor Kathleen Stock tomorrow, but this is a classic where it seems to me that someone who's expressed quite legitimate views is subject to horrendous abuse and basically allowed to simply put up with it herself. It was very, very late on that the university came to her defence. And my lords, there are so many examples of this, mainly to women, because there is a lot of misogyny in this debate, mainly to women, who are left defenceless by pathetic public bodies who are frightened to upset certain groups like Stonewall. We know it, my lords, the noble lords. We know it. How many government departments where policy has been developed by officials, where ministers have actually had virtually no say in how it's being developed. And my appeal tonight, my lords, to the Minister is to take it seriously, to say there is a legitimate debate, not one where we're going to call each other names. We're actually going to start to discuss these issues, because it's never been allowed, my lords. There has been no real public debate or scrutiny in Parliament. And they're so sensitive, and we're going to come to this now every bill that goes through, this debate is going to take place. And I just think the government needs to really... We know government is split. We know government is split on this. But they have got to get themselves together and start to have a proper dialogue. And that's the appeal I make to the Minister.
Well, my lords, I'm afraid it's not just the government that's split on this. My lords, rarely have, with two notable exceptions, rarely have so many noble barons spoken with such passion and at such length for the dignity of women. And there is nothing wrong with late flowering feminism. I say that quite sincerely to the noble Lord Blencathra, who I had the privilege of advising as a young lawyer in the Home Office some years ago now. So there's nothing wrong with late flowering feminism. There is nothing wrong with speaking up for the dignity of all people, actually. And I say that as a self-identifying feminist and human rights campaigner. But, my lords, the debate has ranged widely, which may be fine, even at the lateness of this hour, but it's ranged beyond the specific issue. And I know that noble lords have brought up various issues to do with the lexicon and to do with whether people feel that their dignity is lost and somehow their femaleness, their womanhood is challenged by newcomers, migrants to their sex, etc., etc. But to get back to the actual issue, which is that because life is complicated and prisons are vulnerable spaces, and everybody in prison is inherently potentially threatening, but also potentially vulnerable. To get back to the actual substance of this amendment and what it's trying to address, I say to the noble Lord Blencathra, if he and I were trapped in a lift with a third person, and that third person, this is just a hypothetical, it's not an invitation, I promise. If I were trapped in a lift with the noble Lord Blencathra and a third person, and that third person is a cis woman, born a woman, still a woman, always a woman, But nonetheless, a white supremacist with previous convictions as long as your arm for violence against non-white women, I would feel much more threatened by the presence of that offender than by the presence of the noble Lord Blencathra. Now, he's looking quizzical, but the point I'm making is that the Secretary of State has responsibilities to people in custody in particular and people in vulnerable spaces that cannot be dealt with the blunt instrument of an amendment like this, which, and I'm not making nitpicking points, I'm trying to address points that I think that the noble Lady Baroness Brinton was trying to make early on, and forgive me, and it's no criticism, but some noble lords responded subsequently, no criticism, with speeches understandably carefully prepared in advance without the opportunity to hear her rather sensitive and thoughtful setting out of the way in which the government to date is trying to deal with its administrative and serious human rights responsibility to deal with all vulnerable people in prison. And in the hypothetical lift, I would be at far greater risk, I suggest, to the noble lord from the white supremacist with the previous convictions. And this is not a total hypothetical, because this has happened in male prisons where non-white offenders have been murdered by fellow cis males, that being the term for people born and always a man, because of a lack of diligence about the offending profile and the attitudinal profile of the person. So this is not going, if we really care about people being safe in custody, which we must, this is not going to be resolved by a blunt instrument. And this isn't a drafting point and it isn't a nitpicking point. It's a point about, in my view, we have too many people in prison anyway. We have, I would suggest, too many women, and we need to pay more attention to who is with who and how we're taking care of them. Now, something like this amendment that says, for the purposes of imprisonment, your birth sex is always your sex for the purposes of incarceration, would mean, my lords, that a cis woman, someone born a woman, who then went through hormone therapy and possibly even more interventionist therapies and even surgery, would be always in a woman's prison. And that would not necessarily always be the right outcome. And so what I'm trying to suggest is that, yes, I care about being a woman, and yes, I care about being a feminist, but I'm a human first and foremost. I don't hate men, I don't fear all men, and I'm not a self-loathing cis woman. I believe that we, in this place, in this committee, perhaps more than anywhere, we should be capable of taking some of the heat out of these sensitive issues, as I think we tried to do in an earlier, and I called it historic debate. And debates about the lexicon and wider dignity, important and heated though they are not going to make women safer. And they're not going to make prisoners safer. Forgive me.
Men, i.e. who feel they're women, but men who have a genitalia being in women's prison. We're not talking about men who had operations. We're talking men who can be actually, after being in a prison for several months, they might have needs and they can attack women. And some of those men are paedophile and violent.
Noble lady, and I do not call her a late flowering human rights person or feminist. And I know that when she, on another bill, spoke about, for example, parental alienation, she was very clear to identify and recognise the fact that this was behaviour that was something that people of both sexes were capable of. And I would say to her, if she'd had the opportunity perhaps to listen to the noble Lady Baroness Brinton's remarks, before she prepared her remarks, and I make no criticism because we all do it, she would recognise that the government is already moving quite a long way to deal with these difficult administrative duties of care. And I believe that people of good will and good faith, and I consider this committee to be those people, can deal with this and can deal with it without, using some of the language that, forgive me, some noble lords have used repeatedly. Repeatedly calling people one sex, even though that it's very important to them to be another, and so that doesn't help. This place, this committee, and your lordship's house should not be a place of culture war. This should be a place where we make difficult things a little bit easier because of the rational thought and because of the respect that we pay each other and therefore everyone else.
I just wanted to respond to that because I think another of the points that, following on from what the Noble Lord Hunt said, was that the other argument that comes up all the time is that if you raise these issues, you want a culture war. I mean, which I think you were implying, or I think that the Noble Baroness Chakrabarti was implying. But also, I mean, in terms of terminology, if we're going to all get offended, I don't particularly find, descriptions of people as cis very helpful either. So when it comes to language issues, the point is that there is tensions that exist outside of this place, and we know that. It's disingenuous to pretend that there isn't. I just wanted to clarify, because it was rightly pointed out that this is a question of administrative duties of care. And I think it's been very carefully worded, this amendment, in a very narrow way about a very specific issue. So what is the objection to that? Because this is precisely a responsible administrative duty of care, regardless of any of hyperbole that people don't like other people using, even when they use it.
I thank the Noble Lady for that intervention. And just briefly, if I offended her in any way by my remarks, I do apologise. And clearly, one of the reasons why this is so sensitive is that beyond this committee and beyond this chamber, there isn't yet, perhaps, even a settled courtesy about some of these matters. So if I have offended any member of the committee, I do apologise. But what I will say is that I was born a woman and I still identify as a woman. But I have never called people, I have tried always to disagree well with people, including on the benches opposite, people that I disagree with across the piece, and I've never seen all men as a threat. And I've certainly never seen people of other races or other sexualities or other sexes as a threat. And I'm not calling anybody names in this debate.
My Lords, it's an important debate, and I think I'm perfectly entitled to intervene. I don't see why I can't intervene. My Lords, I agree with a lot of what she said, by the way, about the tone of the debate. The problem I have is this accusation of transphobia.
But I didn't make it.
No, you didn't make it, but it is made by many people. And the fact that those who are perhaps arguing from your point of view never defend people like Catherine Stock when they've been subject to such abuse. Now, I welcome this debate, that's why I intervene, because I think, frankly, this is very helpful to try and set a place here. I agree with the Noble Baroness, my noble friend, that the Lords is the place, above all else, where we can start to have some reasoned discussion. But there are huge tensions and sensitivities on both sides. And I come back again, because I must come back to the Minister. The fact is that... Well, that's very true. She's right to... I'll take that and ask her to respond to me.
So I'm grateful for that. I certainly, forgive me again if I have called anybody names. That has not been my intention at all. I think this is difficult terrain. To be, the path of human rights does not run smooth, and there are all sorts of difficult issues to be dealt with. But there are some people beyond this committee and beyond your Lordship's house who would seek to set people against each other. And the focus of this legislation and your Lordship's focus in this committee should be to ensure the safety of vulnerable people in in prison, whatever sex they were born, whatever sex they now identify as. And really, I was just trying to suggest that that is not just about biology, it's also to do with criminality and profile and attitude and so on. I believe we have too many people in prison. I believe that, therefore, we have too many women in prison. I would defend, by the way, academic freedom and debate, and forgive me if I've not been seen to you know, I believe my record on these matters, on free speech matters, is a decent enough record, but I just urge noble lords to send a signal to the wider world that in this place at least we can disagree well and we can focus on protecting all vulnerable people in prison.
I declare an interest as chair of the Equality and Human Rights Commission. As most noble lords will know, we are the body charged with protecting the protected characteristic of sex, as well as the protected characteristic of gender reassignment, as well as the important, in fact, fundamentally important human right of freedom of expression. All of those things have been discussed today, I think, on the whole, relatively calmly, and debating well. I would start from first principles to say that we should never try to close down debate, and yes, we should debate well. I thank the noble lords, Lord Blencathra, Lord Morrow and Lord Farmer for and Baroness Mayer for proposing this amendment, which seeks to ensure, basically, that female prisoners are protected from harm. This is a complex area where the rights of trans women prisoners to have their legal sex recognised has to be balanced with those of female prisoners who may be fearful of attack if they know that, for example, a dangerous sex offender with male anatomy is housed with them. I think the important point is that when you're incarcerated and you don't have the liberty to leave the place of danger, then the state's duty to look after you is profound. You don't have the choices that other people have. So the noble lords have proposed that prisoners with the gender recognition certificate who are suspected or convicted of violent or sexual offences are treated as the sex registered at birth. I understand the intent behind this amendment, which is essentially to secure the safety of natal women. However, it does raise some issues that I think require further thought. For example, the risk of violence towards trans women prisoners housed in a male prison, as well as to trans men in a female prison. I would urge noble lords to not frame this serious and complex issue in either a numbers game, they're very few, or they're not so few, nor in our own personal frames of what may or may not be our own personal outlook if we find ourselves in that position. My lords, the law is frequently a straitjacket, and it isn't sufficiently malleable to accommodate the complexity of identities around us. At the heart of this issue is the need to protect female prisoners and to ensure that they have access to single-sex spaces, including bathrooms, sleeping accommodation, and other areas that they need. Violent and sexual offenders are a threat to their fellow inmates, regardless of their sex or their gender identity. Cases of assault sadly happen already in single-sex prisons. However, in the case of trans prisoners who may be violent or who may have committed crimes involving sexual assault, it is right that we now need to give additional thought to how they are housed. The law, as it stands, calls for these decisions to be made on a case-by-case basis. While this will be right in many situations, it may also raise the question of how female prisoners can have confidence in their ability to safely access spaces such as toilets within the prison, precisely as they cannot know of the outcome of a case-by-case assessment, rather than the generality of a law which exists for them. I would suggest, noble lords, that further thought needs to be given to what facilities are provided to trans people and whether provision can be expanded for trans people that ensures that all sides of that debate can be safe and secure within the prison estate. There is a further problem with the amendment, is that oddly it is too narrow and doesn't capture the issue of trans men or trans women who don't have a gender recognition certificate, but nevertheless self-identify in the gender and can therefore apply and be granted a place in the relevant prison estate. I don't think the noble lords who put down this amendment intended to keep it quite so narrow. Certainly their speeches don't reflect the narrowness of the written words of the amendment. So, my lords, these are not straightforward issues, and it's right that we give proper consideration to the balance of rights of different prisoners. I don't believe this amendment gets that balance right, but it does ask serious and important questions that need to be addressed in law. So, in concluding, I would say to the noble Lord the Minister that if he is minded to pursue these arguments through report stage of this bill, that he give extremely serious consideration to that balance of rights, the importance of getting that balance of rights correct, and ensuring that all prisoners have the duty of the state to safeguard them upheld as we go forward.
My lords, I hadn't intended to speak, but I would like to support what the noble lady, the Baroness Faulkner, has just said. I think there are two groups of people who need support. I agree with her that the well-intentioned amendment of the Lord Blencathra actually doesn't really meet the problem. These two groups are the women who are women at birth and remain women, and those who are men at birth and become women. Both groups need, even in prison, to have respect for who they are and what has happened to them. I don't think at the moment the prison system is probably well adapted to deal with trans women. And the noble Lord the Minister needs to think with some care as to whether rather more should be done to help that group of women. But the help for that group of women should not be at the expense, and I venture into dangerous ground by saying at the expense of those who remain women. This is an extremely tricky area, and we know from areas outside the prison system just how tricky it is. I don't envy the noble Lord the Minister or the Ministry of Justice for the situation in which they find themselves, because this didn't exist as far as we knew, even 10 or 20 years ago. But my goodness me, it exists now. And there are two groups, both of whom need not just respect, but understanding and care, even within a prison.
My Lords, I have been engaged in the debate on trans issues for many years, and I have the scars to prove it. I have even been criticised for simply engaging in the debate by some trans people for even listening to radical feminists, and by feminists because I'm not a woman. I have met with, listened to, and talked with many people on all sides of these issues, including radical feminists, gender-critical people, trans people, and intersex people. I continue to listen, and I continue to try and understand the views expressed by all sides. And my lords, I sit here and feel my blood pressure rising when I hear the comments of many noble lords around the chamber. And then I think for a while, and I think to myself, it wasn't that long ago that maybe I held similar views until I actually started talking to those people whose lives we are talking about here. People who honestly and genuinely believe that they are in the wrong body, if you like. People who genuinely believe that they are women even though they have male bodies, for example. And that's when you begin to understand that these things that appear completely counterintuitive actually make sense for those people. So I don't condemn people for what they have said, because it wasn't that long ago that I perhaps might have thought along similar lines. But
could I just clarify one thing? Without, I don't know if this, a number of people many people who are trans don't agree with some of the orthodoxies that have become associated with trans activism, because I think the inference was that possibly some people who have a particular view is because they haven't met any trans people. That would not be true. There are whole swathes of people who are trans who don't go along with a particular opinion or political opinion, for example, in relation to prisons in this instance. So I'm just concerned that it's not seen that those people who are arguing a gender-critical view are doing it because they're ignorant and haven't got out enough.
I hear and understand what the noble lady says. But on this amendment, I am clear. We oppose Amendment 214 from the front bench. We do not support the noble lord's amendment, but we completely understand the concerns that the noble lord and other noble lords have, although we feel the risks the noble lords seek to minimise are already minimal, and that there are other risks that need to be managed that are not covered by this amendment. The amendment seeks to amend the Gender Recognition Act in order to reduce the risk transgender prisoners present to others. My lords, this is not necessary, nor is it desirable, for the following reasons. First, there are very few transgender prisoners. In a data collection exercise between March and May 2018, only 44 of 124 public and private prisons said they had any transgender prisoners at all. That there are so few transgender people in prison is also an indication of the level of offending by transgender people and the seriousness of that offending and the extent of the threat that they pose. Second, the risk of mental health problems, self-harm and suicide is far greater amongst the transgender community than those who are not. Clearly, in a prison setting, the risk of mental health problems, self-harm and suicide are likely to be higher for all inmates. And for transgender prisoners, they are likely to be very high indeed. My lords, in November 2015, an inmate who said that she would kill herself if she were sent to a male jail was found dead. Vicky Thompson, 21, died a week ago at the all-male HMP Leeds. Friends said Thompson, who was born male but identified as a woman since being a teenager, had asked to be sent to a female jail at Wakefield. That's the sort of impact that having an unbalanced amendment such as the one that the noble lord is proposing can have on transgender people. Third, if the prison service thinks that the risk presented by a transgender prisoner is such that they should be housed in a prison contrary to their legal gender, the prison service can allocate them to part of the estate that does not match their legally recognised gender. The decision has to be taken after consultation with experts, and it must be taken at a high level, but it is possible. A number of noble lords have referred to the High Court judgment in July 2021, where lawyers for a female in the female prison estate brought a judicial review against the MOJ. The MOJ argued that the policy pursues a legitimate aim, including facilitating the rights of transgender people to live in and as their acquired gender, and protecting transgender people's mental and physical health, is what the MOJ argued. And it's interesting, I'm actually quoting from the same case as other noble lords have quoted from. Lord Justice Holroyd said, it is not possible to argue that the defendant, the MOJ, should have excluded from women's prisons all transgender women, as this amendment proposes. To do so would be to ignore impermissibly the rights of transgender women to live in their chosen gender. Now, the case wasn't actually about excluding all transgender women. It was about challenging how policies applied to those who've been convicted of serious or violent offences against women, as the Noble Lord's amendment does. And the Lord Justice went on to say that trans women's offending history was a factor that the existing policies were required to consider. The need to assess and manage all risks is repeatedly emphasised throughout existing MOJ policies, he said. He continued, in an exceptional case, a higher-risk transgender woman, even with a GRC, can be transferred to the male estate because of the higher level of security which is there available. So there is a mechanism to do exactly what the amendment is seeking to do, but on a risk-assessed basis. The court also heard that expert panels are also involved in the process when allocating transgender prisoners and are expressly required to consider the trans woman's offending history, her anatomy, and her sexual behaviours and relationships. The Lord Justice continued, they can, in my view, be expected to be astute to detect any case of a male prisoner who, for sinister reasons, is merely pretending to wish to live in the female gender. The policies require a careful case-by-case assessment of the risks and of the ways in which the risks should be managed. Properly applied, that assessment has the result that non-transgender prisoners only have contact with transgender prisoners when it is safe for them to do so. My Lords, this is the same case that noble lords have been quoting from. Yes, the Lord Justice said, I readily accept that a substantial proportion of women prisoners have been the victims of sexual assaults and or domestic violence, and that some women prisoners may suffer fear and acute anxiety if required to share prison accommodation and facilities with a transgender woman who has male genitalia, and that their fear and anxiety may be increased if that transgender woman has been convicted of sexual or violent offences against women. My Lords, this amendment says nothing about whether the person has had sex reassignment surgery or not. Because there are trans women with gender recognition certificates who have not undergone gender reassignment surgery. So this, again, the amendment is not fit for purpose. My Lords, there are two sorts of risks that need to be managed here. There are the risks to the transgender prisoner, either from themselves in terms of mental health, self-harm and suicide, or the risk from other prisoners, whether the risk of a transphobic attack or an attack based on their acquired gender, for example, if they present as a woman in a prison housing men, for example. There may be risks that the transgender person poses, perhaps because of previous history of violence or sexual offences, but those falling into this category are few and far between and can be dealt with under the law as it stands. Any attempt to stereotype all transgender women as a threat to women flies in the face of the facts and needs to be robustly challenged. And the implication that transgender women are a threat to children reminds me of the sort of abuse that was directed towards me as a gay man a few decades ago.
The noble Lord is looking at me and implying that I suggested that transgender men were a threat to children. I said no such thing at all. I quoted the case of a male rapist who had raped 2 children. I was not suggesting that this was endemic in the transgender community, that they're a threat to children at all. That is not what I said, not what I implied, not what I intended.
I'm grateful for the clarification that the Noble Lord has given, and I will allow Noble Lords to read the official record and draw their own conclusions from what the Noble Lord said. My Lords, the Noble Lord's amendment only manages one of these risks, arguably the much lower risk. Each case should be and is currently managed on a case-by-case basis, and that should continue. And we oppose the amendment.
We too oppose the amendment. We, I think, all accept that transgender women are entitled to live in their chosen gender. The law protects transgender women and transgender men from discrimination because they are transgender men or transgender women. I think the position that is outlined in this amendment leads all transgender women to be consigned to the male prison estate. A point that Lord Panic made very forcibly. The moment one says that, one sees the total unthought out nature of this amendment. The way forward was, I believe, charted by Lord Panic, Baroness Faulkner and Baroness Brinton. Baroness Faulkner indicated in a powerful speech that one is dealing, in effect, with rights that may conflict. The right of the transgender woman to be properly protected, and properly protected in her choice to be a transgender woman on the one hand, and on the other, the possibility that certain prisoners, including transgender women, can be a threat to other prisoners in the women's estate. The way that that is dealt with at the moment was well outlined by Baroness Brinton in her excellent and detailed speech. The prison authorities deal with it on a case-by-case basis using a series of detailed processes. Should we continue with that, or should we condemn every gender recognition certificated transgender woman who is charged, maybe not convicted, of a violent or sexual offence to being in the male estate? For my own part, it is pretty obvious that one should continue with the current arrangements. They could be improved, I'm sure. I'm not in a position to detail any improvements that could be given to them, but that case-by-case basis must be a better approach than that adopted by the Lord Blencathra's amendment. I would go further and say I do not suggest to the Lord Blencathra and those who've also supported the amendment that they come back with something else, that this is something that is much better dealt with on a case-by-case basis. So we, on this side of the House, oppose the amendment. We don't think it's appropriate. We don't think it even tries to balance rights, and we wouldn't support it coming back at the court.
My Lords, having heard the Noble Lord Paddick, can I perhaps begin with two confessions? First, I frequently listen to and discuss issues with people with whom I firmly disagree, including on occasion members of your Lordship's House. And second, I do not propose to change that approach. This amendment from the Noble Lord Blencathra relates to the management of prisoners who have changed their legal gender by obtaining a GRC, a Gender Recognition Certificate. And the effect of the amendment would be that a prisoner with a GRC who is convicted of or is on remand for a violent or sexual offence would be, and would have to be, held in a prison matching their sex at birth. Can I assure the Noble Lord Hunt of King's Heath that I and the MOJ do take this issue very seriously, but, and with no disrespect to any Noble Lord whose speech has ranged more widely, we are in committee on this bill, and I'm going to confine my remarks to the subject matter of the amendment and not to the broader questions, whether as to Stonewall or related topics, interesting or thought-provoking that they were. The committee will be aware that the MOJ left the Stonewall Diversity Scheme in June this year, but of course I reiterate the Department's commitment to diversity in all of its diverse forms. Our policy is not driven by ideology. It's driven by compliance with the law of the land and to consider protection for all, and I repeat all, of the prisoners who are in our care. Reference has been made to the 39-page policy, and let me just read the section under outcomes. It says this: the high-level outcomes of the new policy framework are intended to strike an appropriate balance, ensuring, first, all transgender individuals are managed safely with their rights properly respected and in accordance with the law. And second, decisions are informed by all available evidence and intelligence in order to achieve an outcome that balances risks and promotes the safety of all individuals in custodial settings and approved premises. This includes an assessment of risks presented to and by transgender individuals. And the committee would have noted the two references to the word balance in that section, as pointed out by the Noble Lady Baroness Falcon of Mogravine, and as the Noble and Learned Lady Baroness Butler-Sloss pointed out, there are two, perhaps at least two, I would say, groups that need respect and understanding in prison. And I do suggest to the committee that that policy is correct in law, and I believe it is correct in principle too. And I would say, with all due deference to my noble friend Lord Cormac, I suggest it is morally correct as well. This is about legality, safety, and also dignity. And so, in answer to the point put to the committee by Noble Baroness Lady Fox of Buckley, no, the world hasn't gone mad. And it is a gross mischaracterisation, I have to say, of government policy to suggest that I or the government have, quotes, no qualms, quotes, about letting rapists share living quarters with women. I assume that point was put because the Noble Lady doesn't understand what the policy is. So let me explain what the policy actually is to her and to the committee. The policy is that transgender prisoners are allocated to a prison matching their legal gender, but can be held in a prison opposite to their legal gender, where otherwise they would present an unmanageable level of risk to other prisoners. And the current policy therefore allows for prisoners with GRCs to be held in a prison matching their sex at birth where that is appropriate. And I therefore can confirm, because I've had this checked, contrary to the position set out by the Noble Lord Blencathra, that there are trans women with GRCs who are now housed in the male estate following the risk assessment process. And the critical point has been pointed out, I think, first by the Noble Lord Panic, and then adopted by others, is that that policy differs from that suggested by the amendment, because the current policy is not a blanket approach. The amendment is a one-size-fits-all approach, or a blunt instrument, I think Noble Baroness Lady Chakrabarti put it. We manage prisoners with GRCs on a case-by-case basis. And I suggest that is absolutely right, because we want to make sure that there are no assaults in any prison by any prisoner on any other prisoner, or of course on a member of staff. The amendment would end the balanced approach. It would mean that a prisoner with a GRC would never be held in the part of the prison estate which matches their acquired gender, even though in some cases this would pose a manageable level of risk and would on balance be the most safe and most appropriate course of action. And it would lead, of course, to a prisoner with a GRC having to be kept in a prison which matched their sex at birth, even when that posed an unmanageable level of risk, which would be an utterly bizarre conclusion. It would mean, for example, that a prisoner who had transitioned from female to male and had obtained a GRC would be kept in a women's prison, even if that posed an unmanageable level of risk to the women they were in prison with. And we are very conscious, as my noble friend Baroness Mayer pointed out, that women in prison are especially vulnerable. And this amendment, I'm sure unintentionally, might expose them to, in fact, greater gender. And it's simply not possible, I suggest, to argue that holding transgender prisoners with GRCs in a prison matching their sex at birth is always necessary and proportionate in every instance. By far the better policy is the policy which we adopt, which is to look at matters on a case-by-case basis. I would also point out that, of course, the amendment only applies to prisoners with GRCs, which most transgender prisoners do not, in fact, have. To pick up, before I sit down, two further points. First, to pick up the point from my noble friend Baroness Mayer on Amendment 292G. I see that Baroness Williams of Trafford has come in to the chamber. I think she or another member of the Home Office team will have the delight of dealing with that amendment on a future occasion, and I don't want to steal her thunder on that this evening. My noble friend Lord Cormac and the noble Lord Hunt of King's Heath said, talk to us. I started off by saying I'm always happy to talk to everyone, and I mean that. However, I would suggest that on this issue, when I think the most important information to provide is how the policy is operated, can I suggest, with respect to noble lords, that perhaps the best way forward might be to replicate something we did on the Domestic Abuse Bill and have what I think I call there a teach-in from officials who will be able to provide you with information and can explain how it works. I've been able to check that they would be very happy to do that. We will arrange that in the normal way. But with that explanation of government policy and with that offer of the teach-in, I would invite noble lords to withdraw these amendments.
It's customary for every peer who's moved an amendment to say it's been a worthwhile debate. Well, actually, I genuinely think it has been a very worthwhile debate, because I think, as the noble Lord, the Lord Hunt of King's Heath said, this subject I don't think has ever properly been debated in this House or in Parliament before. It's a policy invented by officials which past ministers have signed off on, and it is certainly worthy of debate. And I would say to the noble Baroness Chakrabarty, the reason so many men spoke is because there are so many baronesses who normally sit behind her who are afraid to speak on this issue. They've spoken to me privately, as have some on the Lib Dem benches and crossbenches, and they said, please raise this issue, we dare not speak out. Now, that is not right. It should be possible for baronesses on all sides of this House to raise this issue of women's rights. My Lords, in some ways there's been a certain degree of consensus on 3 issues. One, the agreement that the rights of transgender prisoners must be protected. Secondly, the rights of women prisoners must be protected. And third, my amendment is a blunt instrument which fails in certain aspects. And as the noble Lord Faulkner has said, I ought not to bring it back on report. Well, I think with proper discussion, I would need to bring back a radically revised amendment on report. And I would thank the noble Lord, the Lord Hunt of King's Heath, noble Lord Faulkner, and Baroness, the noble Lord, my noble friend Lord Cormac, and Baroness Faulkner of Margarine, for suggesting that we need to get the balance of rights correct. And since the noble Lady Baroness Brinton said the numbers are small, and I dismiss the view, just because it's small, it doesn't matter so much. Well, it may be small, the number of transgender men in prison may be small, but the fear they create in the women's estate is quite considerable. And it's not just the number of attacks that have happened, it's the fear those women have of possibly being attacked, and their rights need to be defended too. So I think if we could have dialogue with the Minister and my noble friends and noble lords opposite on getting that balance right. And since the numbers are small, then why can't we have special units for those men who are identified as women, so they are not, as the noble Lord Panic rightly pointed out, forced into the male estate where they would be victims of violence in some cases, where they're not forced into the women's estate, where women are in fear, rightly or wrongly, that will be attacked. And since we already have some specialist units, can we not have units for men who are identified as women to have their own accommodation with their own like kind, with their own people who also want to identify as women? And I would urge the noble Lord Panic to read very carefully what I said. I did not accuse transgender men at all, or transgender women, of being a threat to women and to being a threat to children. I quoted one man who was a rapist and raped children, and after he went to prison, he then decided that he wanted a GRC and then to identify as women. That is a totally different case from what the noble Lord was inadvertently suggesting I said. So, my Lords, on this occasion, I intend to withdraw this amendment, but I would like to take up the Minister and the noble Lord Hunt and Lord Cormac and possibly Baroness Margarine, if she's permitted to do so, to discuss an amendment which would try and get the balance of rights right, so we protect women and we protect transgender men, and each can feel safe in their own prison space. With those words, my Lords, I beg leave to withdraw the amendment.
It's a pleasure that this amendment be withdrawn. Amendment is by leave withdrawn. We now come to Amendment 214A, which is being moved, in which Baroness Brinton will be taking part remotely. After Clause 124, Amendment 214A, Baroness Brinton, please to move her amendment.